Okay, so again, I'd like to welcome you and thank you for joining us for our webinar this morning. I was pleasantly surprised by the massive response that we've had, to the point where I had to, between yesterday and today, say to people we have not much space left or no space left, because I've had 150 bookings for this webinar. So it definitely seems to me like HR professionals want answers to these questions, and they are questions that are important to you. So we'd like to thank you for taking the time out of your day to join us. And I'm not going to waste a lot of time, because I do know that all of you are busy people. So we're going to sort of get straight into the actual webinar and the questions that we are going to ask, or I'm going to be asking Rachel to answer. But before I do that, just in the way of introductions, so I am Rose Govender from Pro Talent Recruitment, and I am the recruitment manager and also a recruitment specialist at Pro Talent. I've been in recruitment for the last 5 years, but prior to that, I've been in HR for many years, 6 of which was in an HR manager position. So I've sort of worn both hats, and I've sort of sat on both sides of people, and have a fair understanding of HR issues that we would deal with. And on the recruitment side now, I'm exposed to lots that our clients deal with. So Rachel and I met, and we thought that this would be quite a nice idea, because often we don't have the answers to these types of questions, and Rachel is a professional, and I thought that it would be nice for her to discuss all of the issues that we had put as issues we're going to discuss today. So I'm going to give Rachel a chance to introduce herself, but just to let you know, we're going to go straight into the questions thereafter, and there will be a time at the end for Q&A, which we'll answer from the chat, as many as we can. And then we will do a giveaway, 2 giveaways at the end as well. But whatever we aren't able to answer in the webinar because of time constraints, you will have our details, which you'll be able to email us or contact Rachel for to advise further. So Rachel, I'll leave it to you to introduce yourself.
Morning, everyone. So nice to be here and have the opportunity to answer these questions. Yes, as Rose so rightly said, I'm the HR director at HR Easy for You. We actually are an HR consulting company. We actually do all areas of HR besides recruitment, actually. And we work quite well with Pro Talent in that, you know, when they have clients with HR issues, then we're able to assist them. I am actually, and I think it's only fair to say, I'm actually leaving HR Easy for You. So I didn't want to tell you to contact me and then you get a surprise when it's not me actually answering your query. I'm actually not leaving because I love it, my position here and the people and the team. I've actually got an opportunity to go and work overseas. So that's what I'm doing at the end of the month. But I do have a replacement, and she's called Renita Peter, and her contact details should be on here. And any HR, she also has over 20 years HR experience. So I feel comfortable leaving knowing that I've got the HR side in good hands. But these questions that we came up to are the typical type of questions that I get asked at least twice a week. Some of the topics that we discuss, we could actually do a whole webinar just on that topic. So in some areas, we are obviously skimming the surface, and also some, you know, every situation is different. And I think that's one of the nice things, if you're an HR person, about HR, every situation is different and needs a slightly different approach within the area of the law. So if I don't cover your answer fully, it's probably because it could be a topic on its own. But I won't waffle on anymore. Let's start, Rose.
Okay, so you and I have discussed 15 questions that are common that we often get asked by HR professionals, both of them, for both of us, it's our clients. And I think the first question that I want to tackle, because, you know, we do recruitment and we would be very good at and work very well with our client to get the candidate to them. And then thereafter, often we find that because of the induction either happening or not happening, candidates leave. And we really are going to work hard this year to make sure that we can enlighten our clients or give them advice on how their induction program should be. But can you just touch on what an effective induction program consists of?
Okay, I think induction's one of those common, those funny things that everybody assumes a person's going to arrive up on the first day and they're going to fit in, they're going to join, and they're going to love it. But it's a bit like anything. You have to welcome that person. And I think there's nothing more unappealing than arriving on your first day and the people either don't know you're coming. There's security issues for you getting in the building or the car park or something like that. You arrive there, nobody knows you. There's no IT set up for you. So I think induction is really not a rocket science approach. If we were really to think, and I always think, well, how would I want to be treated when I start a new position? So I would expect beforehand that your email address is sorted out, that you've got access. You spend some time with that person. I mean, I've also seen and heard that people arrive, they get basically sat at the desk, a telephone, and then they're left wondering what to do for the rest of the day, or they might just meet and greet. That's not really an induction. So I would always say meet the key players. For some of us, there's a health and safety aspect that needs to be communicated to people. Have they completed their contract? The number of people that get sent a contract, but then nobody actually follows it up to actually make sure that both parties have got a signed copy of it. It just that overall professionalism with people moving around and not thinking twice about moving. You want to look like you're professional. You want to look like you're taking new people or your employees seriously. Even giving the people like a little bit of a gift when they start, like a new notebook and their pens and just stuff like that. People love freebie things like that. Making sure if they've got health and safety equipment that it's there waiting for them, or that you can go and they don't have to wait 3 or 4 days for that sort of thing. So I think induction is a bit of a common sense approach to it. Again, make sure your policies, do people know where to get your policies, procedures, all those sorts of things. But yeah, I think too many people don't do anything and just expect that person to be a number one success. It's really, like I keep saying, it's really not rocket science. It's just about making the person feel welcome, because don't forget, even if that person's on a probationary period, they're assessing you as much as you assessing them. And the competition is quite it's out there. So you need to be professional in the way you induct people, or onboarding as they call it as well.
Okay. So I think that's valuable advice. And I mean, you're probably seeing it all the time where people have not passed their probationary period, and induction forms very much a part of the problem. And with a lot of the questions that I hear, there's not a lot that I can say because it's very HR related, but this is one that I can definitely speak a lot about, because for 2 reasons. Number one, we see the effects of clients not onboarding staff correctly. And the second thing is we have to onboard people that are pro talent. And what I've done is when I took over as the manager, I've made sure that we have quite a detailed induction plan, because this is quite a dynamic, fast-paced environment. And before people get to their desks and actually have to start doing the work, I want to make sure that they are well equipped, to get the job done. So, Cindy and I have been chatting about this topic for quite a long time, and we've got an onboarding talk coming up on the 11th of May at the Pencil Club as well, just because of how much we're seeing that goes wrong with the onboarding process within a company. I think for me, if I can appeal to HR professionals or HR managers or business owners, when the person signs the contract, that is when your relationship starts with the person. I don't know if you agree, Rachel. But the thing is, that constant communication is so important, because it doesn't mean that they sign the contract, all is good. We've seen time and time again that candidates come back to us and they're like, actually, I know I signed the contract, but I'm deciding to stay for whatever reason, whether it's they've been offered more money, or they've had a chat with the current manager or current director that they're working under and realize they actually don't want to leave. It's the company's last opportunity to keep that person and not have to endure the costs of recruiting and training a new employee. So they're going to do whatever it takes to keep the person on if they are good. So in this situation, we talk about good candidates that in many ways are top talent. So I would say, going back to that, is communication with the person from day one, as soon as they've signed, is very important. So I would be, if a person is going to be joining us, I would be calling them like once in 2 weeks, and I'd pop them an email just to say, hope all is going well during your notice period. Like, just say we have an event coming up in a month's time, I'll forward them that details and say, I'm just letting you know, that I know you're starting on the 1st of April, but in May we have this coming up. So it's a constant communication and getting them excited about joining. And just little nuggets of what they can expect when they actually get here. So I think that's important, because the last thing you want is on day one, the person doesn't pitch up. And to be honest, this week we've had 2 people sign the contract, all was good, waiting for them to start this week. Guess what? They haven't pitched up for the job. So we were just having a chat about it in the team today, and the headspace of people, and weird is maybe the wrong word, but it's weird. So you've got to make sure that you're constantly communicating with people that are joining your organization. Companies are losing good employees because of the gap in induction and onboarding process. I think my advice is to think back as a person who starts a new job. What are the emotions you feeling? What is the anxiety? You know, getting into a new building, that smell of the new company, the people, not knowing who's who, not knowing who you can trust. There's a lot that goes on in a person or with a person when they start a new job, and we've got to be cognizant of their emotion. Take cognizance of their emotions, because we're ready to just get them going and get the job done, but they are experiencing a lot because it's a new environment. Have you thought about certain things like, how are your current employees going to be treating this person? What is the culture like in your company? If you know, I mean, everybody's got that, let's say Joe, that's that difficult person, and that might be giving the new person worst case scenario for everything, or might have a bad attitude, or might sorry, somebody's not muted. Please can I ask everybody to stay on mute, because it interferes with the recording. Yeah, so you know, think about, are you briefing people in your company to expect a new person? Are you including them in the process? Think about the person handing over. Often we have the situation where the person handing over is a person leaving, so they bitter in for whatever reason, or they just don't care, or they're so busy getting ready for their new adventure that they're not going to sort of put effort into what they're doing. Think about how they will be treating the person that started in the job. Think about the people in that department whose friend is leaving. So Sue and Grace are best friends. Grace is leaving. Sue is sad about it. And then there's this new person, Joe, that starts in the job. How is Joe going to be treated? Because Joe is the new person in the company and has to now make friends, whereas the old person was friends with everybody. So sort of there's dynamics around that as well. What about the staff that have applied internally for the position and were unsuccessful? And then there's this new person coming in to start the job. How would they be treating that person? Remember, the new person is not going to tell you all this, but these are all the things you need to think about to make it pleasant in the beginning for the new person until they are like used to the organization, got the hang of the job, that sort of thing. Just a few things that I do at Pro Talent when we hire new people. I have a checklist of before they start and a sort of spreadsheet of after they start to make sure that they inducted or everything's ready for them before. And when they start, there's a clear plan of what we're doing for them. So the checklist makes sure that we have everything we need for the new person, from laptop to mouse to diary to a mug to stationery, whatever we need, right? The schedule details all the training that they will go through in the first week, because we do 1 full week of training and the second week is a little bit more relaxed in terms of training. I would sit down and go through the induction plan with them. On the first day, they would have a coffee and cake meet with the team. So everyone sits around the table, welcomes a new person, chats to them, asks them about their family, let's say, gets to know the person. Are you doing that? That's important, because you stick the person into their seat and then they're supposed to sort of find their way and just figure out things on their own. This way, everyone's included in the process. Also, in the team, one of the members in the team, because I have no creative skills whatsoever, decorates their desks with balloons and chocolates and the mug and streamers and does a welcome sign. And it's all very bombastic, let's say. And then also, is there a common drive within your organization where the person can get all the information they need? Make sure they know where to find information, templates, processes, SOPs that you might have, just so that if they're feeling lost about something, they know where to go. Ensure that they have one-on-one time with everyone in the team. So in our team, everybody trains the new person, and they train them on how they do things and I allocate different elements of the process for each person to train. Are they spending time? Are they having a meeting with the director? So if you're the HR person or you're the director, are you scheduling one-on-one time with the person just to get to know them and just to make them feel welcome when they start? Is there somebody showing them the facilities, telling them the company rules, the dress code, office etiquette, if there's certain holidays or half days that you give? Are you meeting with the person every day for the first week, weekly for the first month, bi-weekly for the first 6 months, and after 6 months, probably once a month, just till you feel like they have got the hang of everything, are fully inducted, and they know what's expected of them. So those are just my sort of tips on this, because this is a topic that I can speak about. I'm going to hand back to Rachel, because the second question is very much for her to answer, and that is, what is a valid medical certificate?
Okay, so I think at the moment, we did a survey at the end of last year asking our clients what was the most common HR issue that they were facing at that time. And number one reason was definitely absenteeism. So one of the ways that you manage absenteeism is to come down quite strong on people providing medical certificates. But we also, from an HR perspective, we know that you can go and buy a certificate in the taxi rank. We know you can buy them for $50, I think, the going rate. So it then comes down to validating that medical certificate. And a lot of companies or clients that I've seen don't really know what a certificate, you know, an employee comes, they give you this piece of paper, and because it's got the name hospital or doctor on it, they think they've got to accept it. And that's not the case. The most common thing is a clinic. You know, they visited the clinic. That is not a medical certificate. So if we look at what a medical certificate is, in order to accept that medical certificate, it has to be, number one, from a registered medical practitioner. So that is somebody who is registered with the Health Professions Council in South Africa, and they will have a number for that. So on the certificate, you would look for that number. The second thing, they must have the full name of the doctor, the address, the telephone number, all those sorts of things, the qualification, and there will be a practice number on there. It must have that. It must also say that the person examined this person, so whoever the employee is. It's not just a case they visited. And so often that part of the certificate is there's usually a section where the doctor will rub out and say visited or he examined. They have to examine that person and be able to confirm that the person was not able to work. It's really important that, because often they'll just visited and they'll leave that bit blank. And then obviously sometimes it will state what the reason was. The reason actually is pretty invalid. We don't really need to know that. And it must also state the date on which the employee can return to work. Just be aware that some traditional healers, because that question also always arises, are registered with the Health Professions Council. But if they're not registered with the Health Professions Council, then you don't have to accept those certificates. And you are able to phone that practice. They obviously will not give you any medical information, but you are able to say you want to validate that this certificate came from this practice, because there are people that have stolen, you know, these medical pads and are able to write these out. So you are able to phone that practice and validate that that person went there. And then obviously if they didn't go there, that's a whole different issue that you would need to deal with. So that's just one way that you can make sure. And what I've done in some of my clients is we've actually done a little bit of a presentation, or at least given a dummy certificate to all employees with their payslip, and explained that if you are sick and you need to produce a medical certificate, this is what it needs to have, and we will not accept anything else. So visits to the clinic are not acceptable unless they have all those things I've just said.
Okay. I remember when I was in HR, there was certificates coming from one specific doctor, and it was letter of attendance. And we actually, on investigation, realized that this doctor was giving people certificates without even examining them. So it's so true that needs to be qualified, in the sense that the certificate needs to state that the person's being examined, because it's not easy to get these certificates without even being examined by a doctor. So that's definitely the case a lot of the time. Let's move on to the next question. How do I manage a non-performing employee during their probationary period? This is a very interesting one, Rachel, so I'm going to leave it to you.
It is, and if anybody wants to go to our website, it's www.hreasyforyou.co.za. There's actually a fact sheet under resources on one of the tabs on this topic. So it can be quite a large topic, but also as part of that fact sheet, we do give a bit of a template at the last page for what you can use to manage those employees. So please feel free to go and download that. I think the number one thing is that one of the most common calls I get is, and it goes a bit like this, you know, Rachel, I've got this person, they've been employed for 3 months, I had them on a probationary period, it's not really working out, and they end tomorrow, the probationary period ends tomorrow, I can tell them not to come back. Is that right? And they're so confident that I'm going to say, yes, that's fine. No. So the golden rule I always say to people is that if somebody is not going to pass their probationary period for whatever reason, it should not be a surprise to them. So if you think of it like that, then you cannot go wrong. Is this person aware that they're probably not going to pass this probation? If the answer to that question is yes, they're aware, then you've probably been doing the process right. If it's going to come as a surprise, then you don't. Then you wouldn't have done the process right. So probationary period, dismissing somebody at the end of a probation is less onerous than dismissing somebody that's permanent. The cases have in the CCMA confirm that, but you still have to adopt a fair procedure. So again, it is linked to the induction process, but after a month, I would have a conversation with that person. What's going well? What's working well? What do they need to improve on? How are you going to improve? Are you able to give them any assistance? You know, if they're not grasping your systems, is that because nobody's actually trained them on that system and you've just been expecting them to, you know, we're not all these millennials that can jump on a system and within 5 minutes we've got it. Have you given them coaching and counseling? There is still an onus on the employer to do that. So what I would do is assess that person at the end of the month. If everything's happy and fine, then that's also, you know, we always never give people good feedback. So I think it's as well as giving them bad feedback, if there is bad feedback, even if there's no bad feedback, give the person good feedback. Again, it goes back to the induction process and the success of that. But if they're not, give them a time frame. Okay, you are aware that you're on probation. We do need to see immediate improvement in this area. Otherwise, we may not be able to confirm your employment. So once you've done that, and you don't have to wait for it on a monthly, I'm just saying monthly because most probations are 3 months. But if it's something that's really critical, it might be every 2 weeks. But monitor that person. And then at the end of the 3 months, if it's quite clear to both parties, sometimes people will just say, you know, this is not working out. And you can say to that person, you know, the next step is you've been here for 3 months. We've met on a regular basis. We don't think this is working out, which means that you need to have an incapacity hearing. You need to have a hearing. Somebody needs to explain your side of the story, their side of the story, and then you would dismiss that person. Most people ultimately never get to that stage at the end of probation because nobody wants a dismissal on their record. And there are situations where it's just a bad fit. It wasn't necessarily any one person's fault. Maybe the job was sold inaccurate to that person. There could be lots of reasons that a person doesn't pass their probation. It doesn't always mean that that person is a bad person, if you want to call it that. But like I said, monitor that person's performance and don't let it be a surprise at the end of the process.
Okay, brilliant. If I can just add to that as well, you know, we see that all the time where candidates are not actually told that they're not performing, and then the client will call us like towards the end of the 3 months and say, you know, unfortunately, this person is not working out. Like with us, it gives us, if you're telling us from day one, it gives us the heads up that we need to be looking for, you know, a replacement for the position. Because yes, there's a person and yes, there's a client, but at the end of the day, as a client, you need the job to get done. So it still means you've got to find a replacement if the person is not working out as well. And, you know, I think we, as people, we mustn't be afraid to have these difficult conversations, you know, with people that we've just employed within the company. And I've realized that, you know, you expect people to know certain things, but you take nothing for granted. If you need to readdress the dress code, if you need to readdress certain behaviors that can be tolerated and can't be, if you need to address company culture, and, you know, those are issues that you're finding, you know, that are things that you can address and still work with the person, have those conversations so that they transition better into the role and into the organization as well. And sometimes what we find, and I've found this when I was in HR, yes, the person is not performing, but are we also giving them the tools that they need to perform? Because, like the client can come sometimes and say, what, the person has very poor computer skills. They're not able to, they're so slow on the computer. And then when you listen to the candidate is saying, Rose, I've got this outdated, not even laptop, desktop that is not, hasn't been updated for years and keeps glitching, and they don't have they haven't installed the program or the system yet. So, I think we've got to ask ourselves the question as, are we giving the person the right tools? Are we giving them the right training? The person that's training them, are they adequately training them? Are they trained to train them? Do they have all the information? Because sometimes it's a case of, I'm handing you over to Joe for him to do the training with you, but he's just skimming the top of what needs to get done and assuming you know the rest. So we've also got to make sure that the person is given adequate opportunity to be successful, because we hire people so that they can be successful. None of you sitting on this call will be hiring a person so that you sort of dismiss them within 3 months, because it's too cumbersome, a process, and we want people to add value to our organization. So we also need to give them the tools as well. Another thing that I've learned in HR, now managing the team, is that you've got to be clear about your expectations as well. You can't just assume that the new staff member is going to understand what the expectations of the job, of the company are. So I think have constant meetings where you are saying, these are my expectations. Okay, for the first 2 weeks, you haven't got to that, but I expect in the next 2 weeks that this process you'll be starting to work with this process and get that done. And helping them to understand that they're not performing and the reasons they're not performing. All of those things also makes it easier if the person is not going to work out for you and you have to let them go. It makes the whole process a lot less difficult, and I think a lot less of a sour taste for both parties. So the person, we can have situations where the person has left and they actually will come to us to say, listen, it just didn't work out. It wasn't anybody's fault per se, but it was just that it wasn't the right job for me. They were so gracious about it. I've often had candidates that say, listen, they paid me a month or two salary and they said, listen, go and find the right job for yourself. We've tried, it's not working out. So there's definitely an approach or a right way to doing these types of things. And I think it's important for our company's reputations that we do it the right way as well. Okay, next one, Rachel, what is meant by the term dissertation?
Desertion.
Okay. Sorry, desertion, my apologies.
No, that's okay. So I often see this on a disciplinary notice. So obviously I chair disciplinary hearings, and sometimes I will arrive, I don't know what the charge is, and I will arrive and I'll see that the employee sat there and I look at the charge sheet and it will say that the person's deserted. Okay, so usually what this is the same type of thing as absence without leave. So I see in a lot of employment code of conduct that they will have the company desertion, employee has not attended work for 3 days or more without permission. Okay, that in itself, and it will have next to that, is dismissal. You cannot just dismiss on that basis. So desertion means that the person was absent from work, so they breached their contract by not arriving at work. And this is the key is, but it was not their intention to return. So in that situation where I said the person is sat in that hearing, you've charged the person with desertion, and the person saying, oh no, I want my job back. I had a crisis, I had no transport or whatever, I couldn't come, I didn't desert. Well, then it brings into question the desertion. It was his intention to return to work. So intention is quite hard to prove. So that's why when you get somebody that hasn't been absent from work without permission, then you have to try and follow up and see where they are. So you would contact their friends, the people that you've got as records. Again, going back to the induction, do you have people outside of their immediate where they live to contact? You go and do all of that. You talk to people in your immediate environment. Do they know why this person's at work? And then once you've got that information, you can then start to ask, is it in your intention to return to work? You have been absent from work from the 1st to the 3rd or whatever the dates may be. Please contact XYZ. Is it your intention to return to work? And you keep doing that. And then you get to a point where probably now after 10 days or that, then you can say, if you do not intend to return to work, then we will hold a disciplinary hearing. And then you have the disciplinary hearing. I generally will charge somebody with absent without leave and permission, because if they do come back, you don't have to then go down the whole thing of desertion and intention. But yes, desertion, the term is really that the person doesn't intend to return to work.
Okay. And are you saying 10 days for desertion is a...
Not really. I mean, I just said 10 days. I think it depends on each circumstances, what's happened before. Yeah, you really have to look on it, each case on its own merits. As well, you get those people that do take the odd day off that don't come back to work immediately. And then you get those people, we've all got those employees that never take time off. This would never happen. Something clearly is not right because this is just so out of their character. So you've got to look at each case on its own merits, but you also have to apply the rule of consistency. But you can deviate from the consistency if there's good reason to.
Okay. And then can you enforce the requirement for an employee to bring a medical certificate if absent on a Friday or a Monday?
Or a public holiday.
Or
yes, I see this in contracts and policies all the time. And yes, it is a deterrent. It does set the mood for how you are going to manage discipline. But from a legal point of view, that will not stand up at the CCMA. And the reason for that is because the Basic Conditions of Employment Act is very clear that a person only has to provide after they've been absent for 2 consecutive days or twice within an 8-week period. So it might well be if they absent Thursday and Friday, well then yes, the Friday they were absent, they would be required on the Monday to provide one because they were absent. You cannot just because a person took the Friday and the Monday, that's not consecutive days. So you can have it as a deterrent, and some companies do try to enforce it. And it can be a way of trying to manage absenteeism. But if that's the strongest thing you've got, if you've got somebody with an absenteeism problem and you're going to rely on the fact that they didn't give you that, or you charge them with not providing a medical certificate for a Friday or on a Monday, it's not going to hold up.
Okay. So it doesn't help that you make it part of your company policy or anything like that? No. Okay.
You can say it, like I said, put it in as a deterrent, but don't rely on it solely as, and a lot of employees expect it. It's almost the norm that people say that. But again, and yeah, best of luck with trying to make that stick at the CCMA.
Okay. How do we calculate pro-rata leave?
Okay, yes, when I started HR, this was one of the most terrifying things I always used to get asked. This person only works part-time, how much leave? And I used to hate, I mean, I ended up in HR because I hated maths. So the thought of having to calculate all these things was like really scary to me. But then somebody explained it to me once. It's so simple, I almost kick myself now. So the Basic Conditions of Employment, there are a few ways that you can calculate leave. So if somebody's working prorated, you know, you are entitled to 1 hour's leave for every 17 hours worked. So it's 1 day, or 1 day for every 17 days worked, which is also quite easy to work out. You just really need a calendar to do that. But sometimes clients get confused. If somebody works 9 till 12, for example, every single day, they will say, well, how many days leave does that person get in a year? Now, remember, the Basic Conditions of Employment Act is 21 consecutive days, which is 15 working days. So although that person's working 9 till 12, they're still entitled to 15 days, but it's their working days. So if their working days 9 till 11, then they get 15 days leave of the 9 to 11. You don't have to, like, I've had some employers try to add up, you know, the 3 hours that they work in the morning, and then they fit that, make it a whole day. It's just their working days. So it's 15 of their working days, whether that working day is 8 till 4 or 9 till 5 or whatever it is, it's still 15 working days. Or you can do it on the 1 day for every 17, but it actually will almost work out the same in the end.
Okay. Yeah. Okay, next one is a common one that I often get asked as well, which is what is covered under family responsibility leave? Do you want to maybe clarify that for us?
Yes, again, this is another area that some employees like to take advantage of. I mean, I've had some people where their actual birth mothers died 3 times, and all things like that. So yes, again, this is something you always get that clever employee that thinks you won't remember. So yes, family responsibility leave is when a child, so a child that you've had by birth or that you've illegally adopted is sick, or a death of a spouse or a life partner, or the death of a parent, child, adopted child, grandchild, grandparent, or sibling. So it's not your second auntie removed, your long lost cousin, it's not cousins, it's purely those people, a parent, a child, adopted child, grandchild, grandparent, or a sibling. Okay, it doesn't include the birth of a child. A lot of contracts still say that in terms of guys having parental leave, or when their partner or wife's had a baby. Family leave doesn't cover that anymore. There was something introduced in 2020 for parental leave, and now parental leave is for the birth of a child or for the adoption of a child. So a lot of people and a lot of contracts I still see have under family responsibility leave the 3 days that people are entitled to on the birth of a child. That it's not applicable anymore and hasn't been applicable since 2020. For parental leave for birth, the person is allowed 10 consecutive days. Okay, 10 consecutive days. Not working days, 10 consecutive days. So basically 2 weeks. Okay. And they can claim up to 66% of their pay back from the UIF. So the same way that you would claim maternity leave, the person, it's usually a father, would be able to collect this parental pay 66% from the UIF. Okay, so there's no obligation for you to pay that parental leave. But it is up to 10 days, not the 3 days.
Okay, that's very interesting because it's new. I don't know if everybody knew about this. I mean, I didn't. So that's very interesting. And I think that if you don't have these in your contract, then Rachel, I don't know if you agree, but maybe you must do an addendum according to what's allowed.
Yeah, it depends how your contracts are written. Some people refer you to a policy, which obviously you would have an updated policy in regarding to leave and what is parental leave. There are restrictions on it. There is I think that does define, I think, what a life partner is and those sorts of things. So, you don't get it for every girlfriend or boyfriend if you change your boyfriend or girlfriend regularly. So again, it can be open to abuse. And you need to monitor it. You can actually ask for proof of the events. I technically have never done that. I don't think it helps build trust with employees. And remember, that's what the employment relationship is based on. But if you do have a big workforce and you've got an issue with people taking leave, then I would have asked for that in that situation. But yeah, I mean, lots of companies will have a whole family responsibility policy just on its own. But if it is specified in your contract exactly what you will get, then yes, you should update that contract or do an addendum. But sometimes in contracts, it will say, as amended by legislation or company policy from time to time. So it sort of allows you to have that update.
Okay. And just one more thing on this, Rachel, just correct me if I'm wrong. This does not apply if your parent is sick. It's only if your child.
Yes, you're right.
Sick. Yes.
Your child is sick, it's a death of a parent.
Yes. So often, like when I was in HR, I used to get a leave form for family responsibility leave, and the reason is took my mom to the doctor, or dad was sick or whatever. So we're just clarifying that this is only if your child is sick, but in the event of death of parents. So not if your parent is sick. And then also if you use it for one, so if you use it for if your child is sick, then you can't use it for a death in the family because you would have depleted the 3 years. The 3 days in the year cycle already if you've already used it for a different reason.
Yeah, I suppose it depends. It depends what how many days you've used. Your child might just be sick for one and you've still got the 2 days left.
Yes.
But yeah, if you've exhausted it, it doesn't get replenished. It's not for every particular event. It's for all of these events.
Okay, brilliant. Next question, can I make a deduction from an employee's salary if they break or damage company property?
Okay, so again, this is quite a common clause that I see in employment contracts that companies will rely on this clause that if there's any breakages or they can deduct from. So it's a very blanket, waffly clause about they have the right to make deductions from an employee's salary. in reality, you cannot make. If there is a debt owed to the employer, the employee has to acknowledge and sign an acknowledgement of debt for each and every debt. So you cannot have one clause in a contract that allows you, if to deduct every time they break something or something happens. They have to agree to that. Any deduction always has to be by agreement between the employee, and there's a limit on how much you can deduct in a month as well. So you cannot rely on those clauses. Again, if somebody is doing it repeatedly, then it will come into your disciplinary process rather than this. So don't rely on those clauses. If you are going to make a deduction for a breakage or something, or a motor fine or something like that, then make sure they agree to that for each and every one.
And when you say to an amount, are you saying that like to a percentage of their salary, a maximum to?
Yeah, I knew somebody was going to ask that, and I can never remember if it's 20 or 30 or 25% of their salary per month. But basically, it's proportioned how much you can deduct from that person's salary per month, because obviously the law doesn't want them to have nothing left at the end of the month.
Okay, another pressing one. Do I have to accept a resignation retraction?
Yeah, I think this is something I spoke about at the last webinar at the Pencil Club, if any of you were there. So often an employee, well, not often, but somebody will give in their notice or give in their resignation letter, and then they suddenly think, oh no, I don't want to do this. I want to stay. And the question really is, do you as the employer have to give them their job back? And the answer to that is quite simple, no. So if we go back to what an employment contract is, there's an offer of employment, and then the other person accepts that. So really all a contract is an offer and an acceptance, okay? And that can only be breached by one party through a dismissal, retrenchment, or one of those reasons that the Labour Relations Act allows, or the person resigns. Once that contract is broken in that way, there's no relationship where there's a you do this and I do that. So if you don't want that person back, I would always confirm in writing that thank you for your resignation, we accept your resignation, because that's another thing. You get into muddy waters when people resign, don't want to, and then say, well, actually I didn't give my resignation, I didn't. I might have said I was leaving, but I actually didn't. So always accept that person's resignation in writing, and it could be an email, it doesn't have to be a formal letter. And then if you wanted that person back, well, then that's fine. You can obviously accept that. Otherwise, you basically starting again. You have to have another offer. So if you don't want that person back, you don't have to offer them that back again. You don't have to accept that they want to come back if you don't want that person back.
Okay. And what is meant by the term immediate dismissal?
Yes, I think this is a common phrase that I also hear, can I immediately dismiss? There's no such thing anywhere in terms of an immediate dismissal. Nothing in the Labour Relations Act. And I have this image of my head that an immediate dismissal is when somebody is caught doing something quite serious, like theft or something like that. They get called in, the manager says, I saw you taking this, so-and-so saw you taking this, you fired. That is my image of an immediate dismissal, and we cannot do that. The law does not allow us to do that. So when they say immediate dismissal, I think they mean a summary dismissal. So after you've followed a fair process, you have no notice pay. So you would get summarily dismissed, which means without notice pay. But you still have to have your hearing and go through the procedural fairness aspect. So there is no such thing as an immediate dismissal. You always have to have a hearing where the person is given the opportunity to state their case and the other rights that brings before you can dismiss a person.
And have you seen at the CCMA that even a guilty employee has been given a little bit more because of the process not followed correctly?
Absolutely. Remember, the CCMA assess unfair dismissal claim based on the procedural fairness. So did you follow the procedure? There is a code of practice on dismissals, which lays out the process that should be followed. And then it's also going to look at it from the substantive view, which substantive really means, does the penalty fit the crime? So that's the way I explain it to people. So you could have somebody that's, in fact, there are some cases where it's quite obvious this person was stealing or did something seriously wrong, but if you haven't followed the fair procedure, your unfair dismissal, the employee will win. They might not get as much, but they will get something because you did not follow a fair process.
And in many ways, to avoid the hassle of going up and down to the CCMA, rather just do the hearing within the organization and follow the process and just.
Yeah, I mean, if anybody's in that situation, obviously that is one key area that we do help employers with. We have lots of people that we can provide as chair people, or even if you want to discuss before it gets to that stage, because often, you're often in a very uptight situation when you're in that situation. You found out that somebody is taking your stock or has hit your car or whatever it may be, and you're angry. And when you're angry, you react in a way that is probably your EQ is not actually talking to you, and you react in a very inappropriate way, and you fall foul. So it's better to phone one of us, or even if it's to vent, this person's done this, and often the person on the other end of the phone is so angry that we talk them through the process, calm them down, and say, no, there is a solution, but we have to follow this process.
Yes, understandable. Okay. Next one is, do I have a choice to dismiss an employee with or without pay?
So I think I've partly answered this question just now. It really depends on how the person's dismissed. So when you summarily dismiss a person, that means they don't get notice pay, and that's really for gross misconduct issues. So they don't get notice pay, but they would be entitled to any outstanding leave or any payments that are due to them up until the date of their dismissal. Okay. If you've gone progressively through your disciplinary process, somebody was late for work or whatever, or you're retrenching a person, then you would have to give them notice pay. Remember, it's in the contract. Both parties have to give the same notice. It can't be more favorable to one than the other. And yes, you would have to give notice pay in that situation.
Okay. Can an employer retract an offer of employment?
I suppose this is a sort of the opposite question of, do you accept a resignation retraction? Again, it depends on the circumstances, because remember, a contract is an offer and an acceptance. So once that offer is made and there's an acceptance between two parties, there is an employment contract in place. The contract does not have to be in writing. Ultimately, it does, because you do have to get people written particulars. But for that initial contract to be in place with obligations between the employer and the employee, all that needs to happen is that offer and that acceptance. So the only way you can really retract that offer is if something comes to light, and a lot of people's contracts will have in there that if something comes to light that makes them unsuitable for that job, then you could terminate that contract after following a fair procedure. So things like that would be, maybe they've lied about their qualifications, or they've lied something, or been dishonest, or made you misinterpret things on their CV or through their work experience. That would be a valid reason. I mean, we've had people that have said they've got a degree, and then when you go and check, they don't have that degree. That would be a valid reason to retract that offer. Again, in some situations, if you've offered something but medically they're not fit, or they don't pass a certain medical for some environments, then you could retract that. A work permit, if somebody needs a work permit and they don't get it, that sort of thing. But generally speaking, I think in the most instances, no, you cannot retract that offer because of the contract law that is involved.
So, just one or two things that I've seen with retracting offers, and sometimes it's out of the control of the client. So you had a position, you went through the recruitment process, and then within that month that you were going to hire the person, you come back to us to say, I need to retract that offer because something's changed in the business. So we all of us are in a business in some way, and we all understand that things change, sometimes within a month even, whether it's financials, whether it's structural changes in the department. And I've also been in HR, so I understand how that works. But I think my advice in that instance where you have to retract an offer because of an unforeseen circumstance, it's so important to have a conversation with that person. They may be a candidate from us, they may be somebody that you recruited on your own, is to call them in and have a sit down with them to explain whether they were in a job or not, whether they were unemployed. It's even harder if they were employed and they resigned from a job and they were going to take your job, and now within the month you are not able to hire them. And Rachel, we see this often because we live in a very volatile economy, so sometimes there are changes. But I think how you leave that person is so important, because we end up with a lot of candidates, whether they were through us or on their own, they've had bad experiences with employers for whatever reason. And sometimes you've got to dig deeper in terms of why a person has the type of attitude that they have, or why they respond a certain way. And often when you dig deeper, you find they accepted a position and it didn't work out. I can't tell you how many reasons for leaving on CVs that I've looked at was accepted a position, it didn't materialize, now they're back on the job market. So I think we need to understand the emotions that go and the sort of scar that we can leave when that type of thing happens. And we've got to deal with this type of person quite carefully, because we want them to go back into the job market with a good attitude despite what they've experienced, because the understanding that it was unforeseen is important. Sometimes you'll also find that the person who left the job decided they want to stay. Now you're in a predicament as an employer because you really like the person. You didn't want them to leave in the first place, or they were going to, let's say, relocate and then that didn't work out and they're saying, okay, I want to stay. Then you have that type of situation. Regardless of whatever the circumstances is, you might end up in that situation at some point. I think how you deal with the person that you were going to employ is very important, because maybe at some point you might have that position again, let's say 2 years time, and you really like that person. You want to leave them at a point knowing that if you had the position in your company again, they actually would consider it and understand why you've not been able to take them on this time.
I think there's also a few legal implications there. Yes, from I call that the touchy-feely, nicey part of HR, making sure you communicate the person. Yes, you might, you've also got to look at your reputation as a company. Can you imagine how many people that person is going to go and tell that this people offered me a job and then they said there's no job? That's not going to do your reputation very well in a tough job 100%. Market either. But from a legal point of view, if that was to happen, remember, that's basically an unfair dismissal case. This employer is dismissing you before you've even started. So it's really a retrenchment situation, really. Yes, the person wouldn't get retrenchment pay, but they would still be entitled to notice pay.
Yes.
Because whatever the statement is, obviously they would get the lesser, and it's probably not that much. It's probably like a week or 2 weeks, whatever your notice pay and your contract is. But just remember that is really a retrenchment situation. For some reason, because that person is employed. There is a contract in place, 100%. Especially if somebody has left a job to come to you and then now has no job. I think they would definitely have a claim at the CCMA. I think communication alone and being nice, you might get away with it, but you might not too.
Definitely. Okay, Rachel, the next question, I'll just sort of speak from my experience, and then you can tell us legally, what's the right answer. But the question is, what is considered a reasonable probationary period? And, I think that if your probationary period is too long, it's sometimes to your detriment, because the person feels this uneasiness for the whole period of the probation. Generally, what we see with all our clients, or with most of our clients, is a 3 month probationary period, which seems fair and seems adequate to sort of gauge if a person can get the job done. But sometimes where your sales cycle might be 6 months, or the actual process might take 6 months for a position, example, sales, sometimes that probationary period is 6 months. Is there anything you want to add to that, Rachel?
No, again, I think I would just reiterate what you said. It depends on the nature of the position. Exactly like a sales or a more senior position might have a longer probationary period with it. But yeah, I think it does come down to common sense. But the most common one is definitely 3 months.
Okay. And sometimes I find, and maybe you can provide some clarity on this. Like I'll have a candidate that will say to me, I've got a 3-month probationary period, so I'm only permanent after that probationary period. So, or I'll get an email to say I've passed my probationary period, I'm now permanent. Can you just clarify, when you employ somebody, are they permanently employed even though they're on a probationary period, or does it feel
Yes,
like a fixed term? Right. Because
No,
I get the
they
feeling
are.
that people feel they're on a contract until they're permanent, when they've signed a permanent contract and are on a probationary period. Are we giving them the wrong impression?
I think it's the right terminology. Again, I think we're using, the terminology is that your employment's really not confirmed. But yes, you're permanent. The day you start, you permanent. That contract, if it's open-ended contract, you are permanent. So again, I mean, it sort of crosses this a little bit. What happens when the 3-month probationary period has passed, and in the 4th month, the employer suddenly wakes up that this probationary period has been missed, and actually they're not too happy. Well, then you're starting from ground zero again, basically. Definitely. So yeah, no, I think 3 months is fine, but I think they are definitely permanently employed then.
Okay. And then can I appoint a new employee on a fixed term contract instead of a permanent contract with a probationary period?
This is what I call lazy HR. So this is employers trying to circumvent the rules and regulations because they're too lazy to do it properly. And they think it's an easy way, and it's actually not, because there are only certain reasons why you can have a fixed term contract. So to me, I would do a permanent contract and use the probationary period for the way it was intended. Monitor that person's performance. If they're not working out, then monitor them, counsel them, and coach them, all those things we said, and then tell them at the end of it after a hearing that it's not working out. But to have a fixed term contract, it's really your lazy person's HR. It's not good practice. How committed is that person going to be? It doesn't build trust. The CCMA see through this so quickly. It really is frowned upon from an HR best practice, because there is an alternative. And remember, I said earlier, the burden of proof in a probationary period is not actually as strong. So it's actually easier, if you do it properly, to dismiss at the end of a probationary period than at any other time during an employment contract, even in a fixed term contract. I think the next question is about fixed term contracts. So there's a few points there that will come out, but yeah.
Okay, so let's get to the next question, and I'll round up my thoughts on this whole fixed term contract as well. The next question is there a limit on how many fixed term contracts I can issue to one person?
Okay, so I often get asked this question, and it comes into, I've seen people where they've had 5, 6 contracts rolling. We call them rolling contracts. So there are specific reasons you have a fixed term contract. So things like temporary labor, if somebody's on maternity leave, you would have a fixed term contract. If you've got a seasonal work where there's an increase in work, you can. If it's a student graduate internship program, a specific project or a specific task, if the person's been granted a work permit for a certain period of time, or like, for example, in an NGO environment, they might have got funding for a position for a certain amount of time, or often when somebody's retired and wants to come back on a fixed term. Those are the reasons that are justifiable within Section 1998 of the Labour Relations Act that you can have a fixed term contract. Nowhere does it say that you can have a fixed term contract to try that person out. So the question you need to be asking yourself is, the reason person on a fixed term contract, does it fit within those points that I've just told you as to reasons that you can have a fixed term contract? Because the problem comes in that people are given a fixed term contract and they roll those contracts. So one of two things happens. They either forget they're on a fixed term contract, the date ends, and then by nature they've become permanent because they've just been allowed to continue, or they roll that contract. So when you start rolling contracts, once a person has a perception or belief that that is a continuous employment, and it doesn't matter if you put that clause in there that the employee, this contract, nothing should be interpreted if it's renewed. it's really a rubbish clause. Everybody puts it in there, and I do as well. But it's not going to stand up because it's what you actually do with the contract. So if you are having rolling contracts, there's an expectation that that contract's going to be renewed, and some employers will do that to stop people joining the medical aid, stop people joining pension schemes, so really not giving them the full benefits of being a permanent person because of cost often. And that's not what they were intended for, and that's why the law changed a few years ago, probably quite a few years ago now, to try to narrow or weed out those people that are misusing and abusing fixed term contracts, because they are abused and they are by employers. There's no doubt about it. So what I would say is make sure you've got a justifiable reason, and the minute you create expectation, that person can argue that they're deemed to be permanent. I mean, how if somebody's had 6 fixed term contracts, what reasonable person wouldn't assume that that was permanent because they've had it for 6 years in a row? Even people in permanent positions often don't stay 6 years.
Yes.
It's going to be very hard to say that that position is still a temporary position. So if you're using a fixed term contract for the purpose it was intended for, then that's fine. But if you're using it because you're not quite sure or anything like that, or you're trying to circumvent the law, it will be found out at the CCMA.
Okay, so I'm just going to give you my thoughts on this from a recruitment point, because we obviously dealing with a lot of clients that do have a fixed term contract for whatever reason. But before I just round up with that, because we have come to the end of our 15 questions, and also I see our time is going. If there's anybody that has questions, please just pop them into the chat for now. And then I will go through them, once I've wrapped up the questions, because we probably would have about 5 or 10 minutes for Q&A, and then we'll take it from there. So while I'm just rounding up the last 2 questions, I'm going to give you an opportunity to put your questions into the chat box. So just my thoughts on fixed term contracts. So sometimes I'd have a client that will come to me to say, listen, it is a permanent position, but we want to actually take somebody on a fixed term contract before we make the commitment to take them on permanently, or whatever the case may be, right? And my thoughts on that is, by creating a fixed term contract for a position that is eventually going to become permanent, or is a permanent position within your organization, means we're fishing from a very limited pool. I can only send you people who have just finished contracts, who are unemployed, who are retrenched, who are not currently employed for the position that you have, which means you're cutting yourself out of, let's say, 50% of the workforce that are employed. And realistically, ask yourself the question, like, is it not better to have an employed person with relevant or recent or current work experience in a position? Or, do you want to take a person on a fixed term contract that's been out of work for the last year or has been retrenched? Because let's face it, retrenchment was used a lot in the last few years to weed out non-performers with a lot of companies. We had COVID and floods and all that happened. And what we found with a lot of companies is that they use that as an opportunity to get rid of non-performing employees by way of retrenchment. So when you're looking at a retrenched employee, for whatever reason, be careful that you investigate why they were retrenched, because it doesn't come out straight away. But in recruitment, you've got to be an investigator by nature. So are you selling yourself short by creating this role as a fixed term contract role, or as a contract role when it's actually a permanent role? And are you missing out on all the talent that is currently employed just because you want to take the safer route and you don't want to go the probation route where you've got to manage a person's performance? Because it's not easy to sell a role that's a contract role, even to an unemployed person. I must tell you, we have candidates now that are unemployed that are saying, actually, I'm not prepared to take on a contract role because I want a permanent role. I'm going to wait. I'm going to go for interviews till I find a permanent role, because I don't want to move to a fixed term contract and then move again and it looks like I've got a hoppy CV. So you might even be missing out on candidates that are available, but that do not want to consider a contract position. Also remember, even if you find a good person and you put them on contract and they within your organization, they are constantly emailing us to say, hi, please don't forget about me. Please keep an eye out for permanent positions for me, because I'm not permanently employed with this company and I am looking for stability, because everyone's looking for stability. So obviously we won't be able to do anything with them if they're employed within one of our clients. But the point is, they will be still looking out. They will be still applying every day, which means their focus is half with you and the job that they have been employed for, because they're also busy looking to secure themselves with another company that's going to employ them permanently. So they're not fully invested in the role and in your company. Literally, they've got one foot out the door, and will make excuses to take time off for interviews, or maybe they'll even tell you, listen, this is a fixed term contract, I'm looking for permanent, I've got an interview. But you're going to spend all this time training them and showing them the processes and exposing them to your organization, all for them to leave for a permanent position. And time again, we see candidates leaving where we've placed them with the client and they phone us and say, listen, I'm leaving because I found a permanent job. And then it's a loss to the client that's employed them as well. So the danger is that they will not feel committed to you. They will still be on the job market. And they also don't feel as valued as a permanent employee within your organization because they're on a contract. So even within your organization, they're seen as, oh, this person's on a contract, so let's do the bare minimum for them. Let's not treat them like an employee that's going to come in and be permanently employed with us until they're permanently employed. So they get half your experience that you would give to a permanently employed person within your company. That's just my thoughts on it. I definitely see the caliber of candidates for permanent positions a lot better than the caliber of candidates for contract positions. And sometimes it is a contract position because you've got a project or you've got a backlog of work that just needs to be completed, and that's fine. But rather not make it a fixed term contract if it's a permanent position within your organization. That's my thoughts on that. Rachel, are you ready to tackle some questions?
Yes, I'm reading them now. There's
Okay.
like some quite shall I start at the beginning?
Yes, okay, you can do that.
So the first question is from Marlene. What do you do in a situation where an employer held a disciplinary hearing and the employee does not attend, making excuses she is sick? Employee then resigns and goes to CCMA claiming constructive dismissal. How should employer deal with that? Okay, so I've actually had this situation very recently where I had a disciplinary hearing and the person didn't attend because they were sick. Now, my first question would be, did that person produce a valid medical certificate? So if they did have a valid medical certificate, which is actually what happened in my case, then I would have postponed that hearing and wouldn't have gone ahead with that. It will definitely not hold up in the CCMA if that person's able to produce a sickness certificate, because remember, one of the ways that procedural fairness is measured at the CCMA is the person has the right to state their case. Okay, so if there was a disciplinary hearing and the person wasn't able to state their case because they could not attend because they were sick and they had evidence of that, yes, I think that could be a little bit unfair at the CCMA. It's quite interesting that they claim constructive dismissal, because constructive dismissal is a situation where the person resigns and it actually specifies because the conditions of remaining there have become intolerable, and the onus of proof for that is on the employee to prove that it was intolerable. So in this instance here, that employee has to prove why they had to resign and why it was constructive dismissal. So the burden of proof was moved from the employer to the employee. I don't understand how they would have done that unless there's more to the situation than be heard. But I think that would be, they're just claiming constructive dismissal because they weren't given the opportunities to state their case, because I don't think that's going to hold up. Probably would need to find out a lot more detail. Something tells me there's more to that story than in that little paragraph. Okay.
Rachel, can I just ask one before you carry on? Can you change a person's permanent contract to a fixed term contract during the probationary period?
No.
Okay.
No, not without their agreement.
Okay.
Oh, no, I don't think anybody would agree to that.
Okay. Okay, you can carry on.
Okay, the next thing is, can you extend probationary period from 3 to 6 months after when contract reads as 3 months only? Yes, so what you can do, obviously it says 3 months, it's not working. Again, as long as it hasn't been a surprise to them, you've mentored them, you've monitored them, you've got to the end and you say, you know, there's some aspects I'm still not happy with, you still haven't met the standards that we expect, so we're going to give you a little bit more time to do that. So we're going to extend it by a further 2 to 3 months or whatever the case may be. Yes, the law does allow you to do that. However, from a practical point of view, and I sort of have a golden rule, and maybe again you need to look at the environment that you're in, like sales do have a longer sales cycle than some normal jobs, but as a general rule, I really do believe from my 20 years that if somebody's not going to make it in the 3 months, they're not going to make it, and they're going to become your problem child later. You know, I'm just saying that as my opinion and what I've seen, but that doesn't mean that the law, you can do that if you want to do that, but it's not what I generally advise to do. Okay. Well, okay, what's the best way to handle a freelance employee has the correct skills but is corrupt? You can only pick up the corruption later on. I would say have a contract with a probation period and other protective clauses. This is for a small business. It places a small business in a very difficult situation. Okay, so I'm a freelance employee. I'm not sure, there's no category of a freelance employee. You're either an employee, you're a contractor, or independent contractor. There's no like freelance employee. I presume what you're meaning here is they're an employee, but they work less than 24 hours a month. That would be somebody like that. So if they've got the correct skills, but is corrupt, again, my first thought is somebody who is corrupt does not have the correct skills. And, you know, your business, your reputation, I don't care what they did. If they're in my business, if they were corrupt and I found out they're corrupt, I wouldn't want them anywhere near my business. That would be it. I wouldn't bother with a probationary period. I mean, corruption is a serious issue of misconduct. It's a dismissible offence. You don't need to have a probationary period to highlight that, you know, if you're caught being corrupt in this time, you're not going to pass your probation. Yeah, I don't actually think it's a difficult situation. If the person's corrupt and you've got proof that they're corrupt, I wouldn't let them near my business with a barge pole. That's it. Hi there. Is it possible to have an employee go from a permanent contract to a fixed contract to pursue a change in their role within a company, and would there be any legal implications? So yes, there would most definitely be legal implications here. So what you're saying is somebody wants to go from a permanent to a fixed term contract because they change their role. Okay, so sometimes I do get asked the question, if somebody gets promoted, can you put them on a probationary period for that promotion? Remember, according to the Labour Relations Act and the Code of Practice, probationary periods were designed for new hires, not for existing hires. So what I would advise is, again, what is the nature of the role, and have a conversation about, if it didn't work out, can they go back to their job? It would be a demotion. Is there possibility of that? But you can't change a permanent to a fixed term to pursue a change. Again, go back to the reasons that you would issue a fixed term contract, and that's not one of them. It's one of the ones that I said people try to circumvent the legislation. You can't do that.
And Rachel, what about doing a trial period agreement for trying a person out in a new role, say for a fixed period of about 3 months? Say you have a junior employee and you want to try them out in a slightly more senior position, and you want to see if they, you know, will step up to the challenge and get the job done. What would you think about?
You can do that, but you would have to put in that agreement what would happen if it didn't work out. So are you saying you would leave that job open? And that's actually a classic example where if you're going to leave that job open for 3 months, you could get a temp. The irony of it is you could get a temp as a temporary then on a fixed term contract to cover that person while you're assessing them for that. But if that didn't work, you'd need to put them back. You couldn't just dismiss them for that. And if part of that agreement would be what would happen if it doesn't work out.
Okay.
What about staff that leave without notice period and just leave on the day they send it? Where and how does the notice? This is one of those things that is so unfair in the employment relationship, because as the employer, you have to give a person notice according to the contract. And if you don't uphold that notice, they can take you to the CCMA. In terms of the other way around, unfortunately, there's nothing you can do. It becomes a civil action, and it becomes an issue of a breach of contract. So it becomes a civil process, and you have to take them to court civilly, and nobody ever does that. I mean, the cost, the length of time, and all of that is just not feasible. So it is incredibly unfair. But unfortunately, if a person resigns and leaves tomorrow, there's not much you can do about it unless you're going to be prepared to take them to court. The only thing I would say is obviously you give they might want to reference at some point, and you can, you can explain in the reference what happened and that you weren't happy, and would that person then do the same to the next person? Who knows? But yeah, you can't do anything about it. You can't withhold their leave pay or any of those things to take into account of that.
Okay.
It's very unfair.
And on that topic of giving references, are you allowed to be, as an HR professional, as a business owner, are you allowed to be as honest as you want when giving a reference, or do you feel like you're not allowed to say certain things? Because I feel like there's a little bit of a gray area here, where HR people don't know what they're allowed and not allowed to say.
Okay, I think firstly, obviously from a Poppy point of view, they have to get permission that this person, you can speak to that person. And remember, it's that whole defamation of character thing that it comes out. And I think that's why HR people sometimes, the person giving the reference is a bit afraid. Remember, anything you're saying that is truthful is not defamation. The defense for defamation is the truth. Okay. So, if this person was dismissed and you say it was for theft, and it was for theft, the person might not like it, but you're telling the truth, so you can say that. Okay. Yeah. Okay.
I think you're going to have literally 3 more minutes for questions. So if anybody's questions doesn't get answered.
So if the same doctors comes through, can we tell our workforce that we won't be accepted? No, you can't, unless they don't meet the criteria for valid medical certificate. Although you can make you can phone that doctor to check, and if you still think they're dubious, you can always report them to the Health Professions Council. They'll do their own investigation. Can an employee give 2 weeks notice to end a fixed term contract at the end of the contract? It depends what the contract says. It always goes back to the contract. So if can an employer give 2 weeks notice to end? Remember, at the end of a fixed term contract, it comes to a natural end. You don't have to give notice. The date of the employment ends on that particular date. Yes, it's good practice to remind the person that their contract's coming to an end, but the contract, if it is a genuine fixed term contract, comes to an end on that date. You don't have to give notice. If you have employees who have been with you for over 15 years, can you update their letter of appointment? And my second, if you offer 15 working days leave, and okay, so a few questions in there. Can you, I would say if somebody's been there 15 years, I probably would give them a new contract, like when there's a change in legislation or something, because new things do come to light. But remember, a person, you cannot unilaterally change a person's terms. So you can give them because you want it to look nice or add a few things in, but if they don't want to sign it, they don't have to, because if you're changing anything in it. 15 working, if you offer 15 working days leave, is it legal to set a date? Say yes, you can say when it's going to be. Some people do it financial, some people do it anniversary date. As long as it's in a year's period in total, you can set the to and from date. That's fine. Yeah. And then tally up the amount of days they have not used and give them. Yes, you can do that. But again, it's going to come up to your leave policy, and you have to be very clear in a leave policy what happens with unused leave, because there are plenty of cases where people have left or want to leave, and then they're expecting to get their 106 days annual leave paid out, and the employer doesn't want to pay it out. So make it very clear in your policy. But also there is an onus on you as a manager or an employer to encourage people to take their leave. I have no problem taking leave. I cannot understand these people that have 6 months worth of holidays that they've never taken over the past 10 years. But anyway, yes, you can, but you must be strict and consistent in how you apply your leave. So again, I would have a leave policy that should help with that.
Okay, so maybe I can do the next one. Graduating with a Bachelor of Arts degree, and what do I need to do to get employment? Quick, simple things. Have a LinkedIn profile, be on PNet, make sure that you've got a profile set up on PNet, apply for all the graduate positions, contact agencies, just make sure you're active on social media. These are the few sort of quick initial steps that you can take to gain employment on graduate level. You need to look out for graduate opportunities, internships, contracts where they're taking on HR interns or HR administrators and start from that route. Next one.
Okay. Have a permanent employee, they take time off without permission to go and do a private job. What can we do? We are painting and we're painting. Okay, you do go on to say that you can't prove this, although he's admitted that's moonlighting. And if it's moonlighting at the expense of your business and your company, it's a dismissible offense. It's a gross misconduct. So I think, again, that one would need a bit more investigation. If you do have that situation, you're more than willing to give us a call. But if they're just walking off the job, that's dismissible offense. Of course, it affects your reputation and how quickly you do the job and all of those things. That's definitely a misconduct issue and should be dealt with accordingly. Yes, I think I've answered the next one. Okay, so please rephrase what the family responsibility leave covers. It covers if your child is sick or your adopted child is sick. It also covers the death of a spouse or a life partner. And then it also covers the death of a sibling, grandparent, or grandchild. It doesn't include when a child is born.
Rachel, I think we'll have to stop there. And what I'm going to do is I'm going to share our contact information because there's still probably a few questions that we haven't gotten to, but we are out of time. So basically, whoever's on this webinar, you're free to email or call Rachel or myself for any questions that you have. And we'll be happy to answer you, as soon as we can. We're going to do a lucky draw because there's two books that I want to give away. One is Cindy's book, which is The Unstoppable, and the other one is How Does She Do It? So I've actually got a randomizer here that I'm going to choose two names. I just want to get to everyone's details. So I'm going to choose two names on the randomizer, and then I'm going to call out your name, and our administrator in the office is going to make contact with you to get them delivered to you. I just want to put everything onto the randomizer. 1 second for me. The first one is Christine Ralston. Christine, I'm not sure if you're on the call. I'm just going to double check. But if you are, we're going to make arrangements to get one of the books to you. Okay, I just want to do the second one. The second. Desigan Edward. Desigan, you are the winner of the second book. So we're also going to make arrangements for you as well to receive the book from us. Again, thank you all so much for joining us. I just want to share my screen with our contact information so that you are able to contact us. 1 second for me. If you have any questions, just give me 1 second to get to that. For some reason, it's not allowing me. Let's try and get that done. Okay, I've got it. Okay, so these are basically the books that we've just given as prizes. And then this is our contact information, both Rachel and myself. I would encourage you to email Renita. She's as knowledgeable as Rachel is, because Rachel is wrapping up this week. So I'm not sure if she's going to have time to handle lots of questions, but you're welcome to email Renita on the screen, and you're welcome to email me if you have any questions. If I cannot answer them, then I will refer them to Rachel or Renita. And again, thank you guys for joining us. We appreciate the support. We hope that it's been informative. I see lots of comments in the chat to say thank you, to say that it was quite an informative session. And I do think we might need to have another one because I've had to decline. So too. We've had to decline so many people, and I've had so many requests this morning for people saying to me, please send the recording. So we're definitely going to do that. If everybody's got the details, then I'm going to stop the share. But yes, you're welcome to email us. Have a lovely day further, and thanks again for your time.
Thanks, guys. Lovely talking to you. Thank you.